Attorney Sabido, I need help. My brother Fernando and his wife Olivia owe me a lot of money, and they refuse to pay. I'm at my wit's end.
Can you tell me more about your situation?
My brother Fernando and his wife Olivia run a small but successful online jewelry business. For years, I've been their biggest supporter. I trusted them with my own pieces and even promoted their work. It's always been smooth sailing until this one time. I have something special for you today.
Ate, what have you got this time?
This is 895,000 pesos. Wow, this looks amazing. Yeah, ito pa. See? Where did you get this, ate? A friend of mine was looking to let it go, so I bought it. Kaya lang I need more funds for the bigasan eh. So I thought about the two of you.
Just like the gold bangles you bought us last time. It's all that in days.
Every time we do business, it works out so well. That's why I trust the two of you. And we really appreciate that, Ate Margaret. You've helped us get some really good sales. I think let's do the same arrangement. You keep those jewelries, and then after 15 days, if I don't hear from you, I'll consider it sold.
That's fair. We'll just do our best to sell it quickly.
Of course. So here's the full amount, 895,000 pesos. But remember, 15 days, ha? If I don't hear from you, I'll consider the jewelry sold.
Understood.
Fernand, can I pause the check now?
Ate, let's just wait a little longer. Things have been slow. We just need more time.
You promised that was our agreement.
I'm not trying to run away from this. Just please don't deposit the check yet. I'll tell you when you can.
Okay, I'll wait. Attorney, I never expected things to get this far. I thought I could help them get a few more pieces and maybe they paid me back once they sold them, but it didn't stop there. They even borrowed money.
I still remember the day Olivia asked to meet me at the coffee shop. Then she said, Ate Margaret, can I ask you for a favor? I already knew what was coming. She needed money, 50,000 pesos for their inventory. She said they had found a good deal on brooches, and if they bought them now, they could sell them quickly and make a big profit. I promise it's a sure deal, she said. I wasn't sure. 50,000 wasn't a small amount. She pulled out an investment deck and showed me slides about how they sold second-hand jewelry and how I would get an 18% share in their business. And she was really selling it hard. And so I asked, 12% and you guarantee I get my money back? She smiled confidently and said, Yes, ate, no risk. You know our business is growing. We've been doing this for months. I was still thinking, but in the end, I opened my bag, took out the money, and counted it in front of her. All right, I said, but 3% on top of everything. At that time, I thought it was a good deal. I trusted her. They wanted to show me some limited edition pieces.
So, Ate Margaret, nakita niyo na po ba yung pinadala namin sa inyo?
Oh yeah, actually. And they do look good and promising. Hmm, sure ba talaga kayo that they're gonna sell?
Yes, it will, ate. We assure you.
Okay, but how much is it this time?
Ate, 90,000 lang to. Mabilis lang to. Babalik din agad yung puhunan.
Then and there, I loaned them the 90,000 pesos attorney. I did emphasize I need the money back soon and that they please, please, please pay on time. But sadly, they did not. Loan after loan, they kept asking. And I kept trusting. Until I realized just how deep they had dug themselves and me into this.
I feel like I've been tricked, attorney. I went out of my way to help them, and this is what happened. I just want to get what I'm owed.
I went to the bank to deposit all the checks. I handed them to the teller. She took them, scanned them, and typed on her computer. I waited, trying to stay calm. Then she looked up. Something was wrong. She said the checks were dishonored due to insufficient funds. Dishonored? How? They swore these checks were good. They promised this wouldn't happen. I want to make sure they can't do this to anyone else. I even went to the barangay hoping for an amicable settlement.
I hope my brother shows up today.
You should give him a little more time to arrive, ma'am. It's not unusual for people to run late.
Maybe he's just running late, Kapitan. He promised to show up today.
Ma'am Margaret, I'm afraid that it's been over an hour. There's no sign of your brother. I'm sorry, ma'am, but without his presence, we can't proceed with the settlement. You may consider scheduling it.
This isn't over. If he won't show up today, then I will just give him one more chance. But that's it.
Good afternoon, Ma'am Margaret. It's really good to see you here today.
I hope Fernando comes this time. But he did promise. He has to come. He's done it again. This is just like last time. He said he would come, but he did show up again.
Two hearings, two chances. But Fernando never showed up. He didn't even bother. I am left with no choice.
I'll go ahead with the civil action, attorney. I just want to make sure that they understand that they cannot just take advantage of me like this.
Rule 8. Manner of making allegations in pleadings. Rule 8 of the Rules of Court has 13 sections.
Section 1. In general, every pleading shall contain in a methodical and logical form a plain, concise, and direct statement of the ultimate facts on which the party pleading relies for his claim or defense, as the case may be. If a defense relied on is based on the law, the pertinent provisions thereof and their applicability to him shall be clearly and concisely stated.
In Margaret's case, we must make sure that the complaint presents a plain, concise, and direct statement of the ultimate facts relied upon by Margaret. The evidentiary facts, such as copies of checks and loan agreements, are referenced but not exhaustively detailed.
Section 2. Alternative causes of action or defenses. A party may set forth two or more statements of a claim or defense, alternatively or hypothetically, either in one cause of action or defense or in separate causes of action or defenses. When two or more statements are made in the alternative and one of them, if made independently, would be sufficient. The pleading is not made insufficient by the insufficiency of one or more of the alternative statements.
The complaint properly sets forth alternative causes of action, clearly delineating different claims related to unpaid jewelry sales and personal loans.
Section 3. Conditions precedent. In any pleading, a general averment of the performance or occurrence of all conditions precedent shall be sufficient.
Under Article 151 of the Family Code, a suit between members of the same family shall not be entertained unless it is alleged in the complaint that the disputants have made earnest efforts to resolve their differences through compromise, but these efforts have not succeeded. The attempt to compromise, as well as its failure or inability to succeed, is a condition precedent to the filing of a suit between members of the same family.
Section 4. Capacity. Facts showing the capacity of a party to sue or be sued, or the authority of a party to sue or be sued in a representative capacity, or the legal existence of an organized association of a person that is made a party must be averred. A party desiring to raise an issue as to the legal existence of any party or the capacity of any party to sue or be sued in a representative capacity shall do so by specific denial, which shall include such supporting particulars as are peculiarly within the pleader's knowledge.
Here, the complaint states the legal capacity of the parties to sue and be sued. Aside from the legal capacity, it is also required that the plaintiff or the petitioner must have the locus standi to file a case. There is no doubt that Margaret has the legal capacity and the locus standi. As a creditor, she has an interest in the outcome of this case. She was the one who lent money to Fernando and Olivia, and it is her fund that have not been paid back.
Section 5. Fraud, mistake, condition of the money. In all averments of fraud or mistake, the circumstances constituting fraud or mistake must be stated with particularity. Malice, intent, knowledge, or other condition of the mind of a person may be averred, generally.
Section 6. Judgment. In pleading a judgment or decision of a domestic or foreign court, judicial or quasi-judicial tribunal, or of a board or officer, it is sufficient to avert the judgment or decision without setting forth matters showing jurisdiction to render it.
Section 7. Action or defense based on document. Whenever an action or defense is based upon a written instrument or document, the substance of such instrument or document shall be set forth in the pleading, and the original or a copy thereof shall be attached to the pleading as an exhibit, which shall be deemed to be a part of the pleading. Section 8. How to contest such documents. When an action or defense is founded upon a written instrument, copied in or attached to the corresponding pleading as provided in the preceding section, the genuineness and due execution of the instrument shall be deemed admitted, unless the adverse party, under oath, specifically denies them and sets forth what he claims to be the facts. But the requirement of an oath does not apply when the adverse party does not appear to be a party to the instrument, or when compliance with an order for an inspection of the original instrument is refused.
Section 9. Official document or act. In pleading an official document or official act, it is sufficient to aver that the document was issued or the act done in compliance with law.
Section 10. Specific denial. A defendant must specify each material allegation of fact, the truth of which he does not admit, and whenever practicable, shall set forth the substance of the matters upon which he relies to support his denial. Where the defendant desires to deny only a part of an averment, he shall specify so much of it as is true and material and shall deny only the remainder. Where the defendant is without knowledge or information sufficient to form a belief as to the truth of a material averment made to the complaint, he shall so state, and this shall have the effect of a denial.
Section 11. Allegations not specifically denied deemed admitted. Material averment in the complaint, other than those as to the amount of unliquidated damages, shall be deemed admitted when not specifically denied.
Section 12. Affirmative defenses. A defendant shall raise his affirmative defenses in his answer, which shall be limited to the reasons set forth under Section B, Rule 6, and the following grounds. First, that the court has no jurisdiction over the person of the defending party. Second, that venue is improperly laid. Third, that the plaintiff has no legal capacity to sue. Fourth, that the pleading asserting the claim states no cause of action. And fifth, that a condition precedent for filing the claim has not been complied with. B. Failure to raise the affirmative defenses at the earliest opportunity shall constitute a waiver thereof. C. The court shall motu proprio resolve the affirmative defenses within 30 calendar days from the filing of the answer. D. As to the other affirmative defenses under the first paragraph of Section 5B, Rule 6, the court may conduct a summary hearing within 15 calendar days from the filing of the answer. Such affirmative defenses shall be resolved by the court within 30 calendar days from the termination of the summary hearing. E. Affirmative defenses, if denied, shall not be the subject of a motion for reconsideration or petition for certiorari, prohibition, or mandamus, but may be among the matters to be raised on appeal after a judgment on the merits. Section 13. Striking out of pleading or matter contained therein. Upon motion made by a party before responding to a pleading, or if no responsive pleading is permitted by these rules, upon motion made by a party within 20 calendar days after the service of the pleading upon him or her, or upon the court's own initiative at any time, the court may order any pleading to be stricken out, or that any sham or false, redundant, immaterial, impertinent, or scandalous matter be stricken out therefrom.